I'm trying to find you again. Hang on. Ah, there you are. Oh, Sandy, you'll have to unmute again. And I believe y'all will have to unmute also.
Can you hear us?
Oh, yes, now I can hear you.
I was like, I'm just trying to make sure.
Good. Okay, technology, gotta love it, right? Okay. Now where was I? Okay, oh, I was looking at Sandy's declaration. Well, I was trying to anyway. Hang on just a second. There it is. Okay. Have to make it bigger so I can read it.
Do you want me to say what I was saying when we got cut off?
Yes, please.
Okay. So what I was saying when we got cut off is the last text that I received or communication that I received. And I believe that I may have added that one in the stuff that I sent, but I did resend it this morning. And what that said, it's two messages from Saturday at 3:58 p.m. and it says that, hi, Sandy, I'm sorry for not keeping up conversations about the lease and all. It's hard for me to get a chance because I'm always working and I had no downtime to get with you. I really don't want evictions on my record. I did go see your David the other day. And he had told me that he told your mom that 125 a month is what they agreed to take care of Tough and to keep his side of the property mowed and picked up. I really am truly sorry. And then at the same time, 3:58, an additional message came in, but it's a different message. Hello, Sandy. I hate that it has come to this point. I would like to come to some kind of agreement outside court. To my knowledge, since before your mother's passing, I was told I do not have to pay rent, just utilities and taxes. I am very hesitant about how the lease was written. I have been in touch with David. He informed me that he doesn't want me to leave. He said the rent would be $125 a month. So I'm confused and I feel like there's a lot of miscommunication. So what I have to say to that is, Tammy is considered a squatter. She is not signing the lease. She is not getting out. She is not communicating with me. She's claiming that she doesn't have time to communicate with me, but somehow she found out that my brother had been moved to Randall County and she went there and visited him, not once, but twice now. And she didn't call me right after they had a conversation on Friday. She sent me a text an entire day later, two different text messages with this communication. And I spoke with him this morning and I asked him about this information. And he said what he said to her was that the communication mom had given to him was that Tammy was paying $125 in rent when she lived there with my mom. And regardless of the situation, she has been given an opportunity, and she was verbally made known that at the 3-month mark, a lease agreement would begin, or, she could get out. And at May 6th, the lease agreement was sent. May 11th, there was more communication, and not since May 11th had there been communication until Saturday when she sent these messages. And she said she would like to come to an agreement outside of court and doesn't want an evictions on her record. And I would agree that I did not want this to come to court, but she had not communicated or tried to say anything to me that she thought the rent was too much, which is what she presented in the answer. And yet she has an attorney present today, which I don't know the arrangement there, and it's not for me to know, but nothing was communicated in that. And so basically, this needs to happen. And you have all the evidence and information.
Okay, thank you. Okay.
Hi, Your
I
Honor.
forgot your name. I'm sorry.
No, you're fine. Okay, Judge Lemons, the defense has filed a motion to dismiss because Sandy Thomas lacks standing to even bring an eviction case. If you look at the property, Armstrong Property County records, the property at 103 South Cherry is still listed under Wilma Jean Hargrove Life Estate. Therefore, a affidavit of death and the death certificate have never been recorded in Armstrong property records. If you refer to the inmate declaration that the plaintiff presented, it specifically only gives her authority in affairs pertaining to the transfer of ownership of property at 103 Cherry Street from Wilma to the care of David Leroy Hargrove. And then at the very end, it says, this instrument will expire the date and time in which transferred ownership and fulfillment at will is signed and executed. She has not done that by transferring the estate out of the estate into David's ownership. Therefore, the superior right to possess the property still lies with the life estate of Wilma Hargrove, and Sandy Thomas has no authority whatsoever over 103 South Cherry.
There is no life estate, and you can look on the Armstrong County Appraisal District that it is 100% ownership of David L. Hargrove at the TDCJ unit, which has since been relocated to Randall County. And if you'll see the deed and information, that is a Ladybird deed to him upon her deceasing.
Your Honor, Wilma Hargrove has 100% possessory interest in that property through a Ladybird deed, and the superior possessory interest still resides with the life estate until an affidavit of death and the death certificate is filed in the county, is recorded in the property records of the county that it resides. That still has not been done. According to David's inmate declaration, that's the only authority he gave his sister. His sister has gone and filed an eviction without the proper procedure. Our argument is this should be dismissed because she lacks standing. She has no interest in the property whatsoever. The only authority that she has received is to transfer it from her mother's life estate to 100% ownership and possessory interest of her brother.
This is what the declaration states. Texas residential, like tenant law, landlord law, you can deem anyone a landlord or a landlord's agent. I can have an agent act on my behalf, even though I'm the landlord. If we would like to find that information, we can do that as well. I am the landlord. I gave plenty of opportunity for Tammy to sign a lease agreement moving forward. And if she did not choose to sign a lease agreement, she could choose to leave. She has no legal rights to be there. It is not her property. She cannot be there. And if we need to reconvene at a later date, after we've had David sign whatever he needs to sign, and I can present that affidavit and death certificate to the county today, I will do so.
Okay,
She has lived there, and she was made aware that 3 months a lease would begin. She's known, and at that point in time, it's been 12 days without communication. If she didn't want, and she was reaching out, she was begging in this text here. She's begging to my brother multiple times that she didn't want to be evicted, and what could he do? She would put money on his books. She would pay the taxes. She would mow the grass. She would do the dog, like keep up the dog, and she would send pictures of the dog. And
Yes,
she's
Your
grasping
Honor.
for straws.
okay,
So
Sandy, hang on 1 second. Okay,
May I
ma'am?
present my case
Yes.
prior to her rebuttal? Okay, at this point, we believe it should be dismissed because she has zero interest in the property. If I were to move forward, when she argues about the lease agreement that was not signed, there's not even an amount that she was telling the tenant on what she was owing. So you can look at the lease agreement that Sandy Thomas filed with the court, and it doesn't state when it begins, when it ends. She is requesting excessive.
that is based on when the
Objection,
tenant
Your Honor.
approves the agreement and
Sandy,
signs.
hang on just a minute, okay? Let her finish.
Okay, so that is to the lease agreement. I would never advise my client to sign a blank lease document that someone can go and fill in at a later time. I've also included a text message from the deceased. Since she has 100% possessory ownership in the property right now, the estate still does. The deceased actually sent a text stating that she does not, it was sent to my client's daughter. And it states that she does not want to, she wants to make sure your mama has a place to stay when I'm gone. She'll have to pay taxes and she'll have to pay utilities, but that's it. She will always have a place to live. Then no one can take from her. Worry about your mama. I'll meet with the lawyer in a week or two. I got it all arranged. That is a direct message from Mrs. Hargrove. She wanted, my client took care of Mrs. Hargrove the last 4 to 5 years of her life. She actually lived in, provided care for her. The utilities of 103 South Cherry are in my client's name. So she pays all the utilities on the property. Under Texas law, at the very minimum, I am still arguing that Sandy Thomas lacks standing to even bring this, and the case should be dismissed off that. In the alternative, I'm going to argue under Texas law that Ms. Thomas failed to present the proper notices as required under Texas law. This would be considered an oral month-to-month agreement. Therefore, based off that oral month-to-month agreement, if I could bring your attention to chapter 91.001, that is considered the notice for termination for certain tenancies.
Is this in an email that you sent?
It's case law. You could probably Google it. It's Texas Property Code 91.001. And if a tenant, if she would like to call this a landlord-tenant issue, the tenant is on an oral lease that she had an agreement with the estate. She has been keeping up her end of the agreement. Therefore, she is entitled to a 30-day notice of termination prior to Texas Property Code 24.005 kicking in, which would be the 3-day notice to vacate. Never did my client receive a notice of termination, putting her on notice that Ms. Thomas would be filing, wishing to terminate the oral agreement between the estate and my client. So there needed to be 2 notices sent. She did enter into the property and post a 3-day notice to vacate. Based on all of those, we're asking your honor to dismiss this case.
Okay. Sandy, do you have a rebuttal?
I do. Based on the utilities were to be put in the tenant's name before my mom had been placed on hospice and before she died. And I had to go to the city after my mom died and have the water shut off because it was still in her name. Tammy claimed that her mom, who was only 3 years older than her, wanted the utility switched to her name so that she wouldn't have to pay a deposit or anything like that. And the only thing that she had switched over was the internet and the electricity. And that is good that she has that. I didn't want this to happen. But you cannot just stay in someone's place because you don't want to pay what they're asking you to pay. You can communicate that. That wasn't communicated. I don't feel like that has any basis, or truth to that. If we're going to enter in text from a dead woman, which has no bearing on this, then I have a slew that I can print and add, and we can reconvene the hearing. But I have journal entries for the way that Tammy treated my mom and did not help my mom. She did not care for my mom. She wouldn't so much as do the dishes, take out the trash, vacuum the floor. You should have seen the place.
Objection, Your Honor. This does not go to the eviction process.
Exactly. Neither does your evidence of my mom being in this. It doesn't all. It's the same. So. No.
On this, since I have not had a chance to truly look over everything, I would like to reconvene at
Your Honor, we've already had the hearing. Request for a judgment. If you would like time to make a judgment, I completely understand, but a continuance at this point is not proper.
Then I am requesting some time to look over this and look over it properly, and then I will come back with my judgment.
Is it today, or you'll email it to us?
It'll be later today.
Do we stay in the court, or are we dismissed?
No, I can email it to you if you will leave your email to with my clerk. That way you don't have to stay around. And then I will get back with you. It'll be later this afternoon.
Perfect.
Okay.
Yes, ma'am.
Okay.
All right.
Thanks.
Thank you. And that will be all.
Thanks.
Trying to figure out how to do this. Hang on. Well,
Send us her link later, but how do we exit out of here?
oh, Sandy,
Yes.
I will, I'm going to look over everything for sure. And while I'm here, I'm going to ask some other opinions of some things.
And I have witnesses if I need, and I have other evidence that I can submit. And I have I can do whatever I need to legally. I have all the paperwork and all the everything. And I have phone conversations, journal, and I have everything. She has no legal basis. So
Okay.
I hope that you do look over the evidence and see that key, that thing of that was on a whim, and she has an attorney, but she has no time to talk to me or respond to me or any money. The answer or her reason for dismissal and her answer to the citation was that she couldn't afford it, but she never mentioned any of that. So it's none of the evidence lines up. And any of the messages that she sent, a message
Well,
from her
the
daughter.
attorney is from legal aid, so she's probably a pro bono.
Okay. Well, anyway.
But yes, and y'all have not rated her will or anything that you
There's no estate, there's no will at all. She couldn't afford to do any of that.
Okay. So
that's why it's ladybird deeded, and that's why it has no foundation, what she's saying. Once it's ladybird deeded, it's automatically in his name, and you can look up right now, it's 100% ownership, David L. Hargrove, in his name on the Armstrong County CAD. And yeah.
Okay.
So.
All right. Yes. I will look everything over, and then I will get back with y'all.
Perfect. Thank you.
Okay. Thank you.